Yes, the cameras are okay to be up even farther if they want to be, so they could film the people testifying. That's okay. Yes, I'm fine with that. Okay, we're going to call Senate Judiciary to order. We are being televised. Madam Clerk, please call the roll to establish quorum.
Chairman Jones?
Here.
Senator Shoemaker? Here. Senator Rocca? Here. Senator Emmons? Senator Bito?
Present.
Mr. Chairman, you have 4 members present. There is a quorum.
I'll make a motion to adopt the February 6, 2018 committee meeting minutes. Without objection, they are adopted. The first bill on the agenda is Senate Bill 713, Senator Marlowe. And would you introduce your guest too, please?
Mr. Chairman and fellow senators, thank you for taking up the time to take up my legislation, Senate Bill 713. We are very excited to be here with this before you today. I am happy to have here today on my right Kerri Kasem, daughter of Michigan's own radio legend Casey Kasem, and Robert on my left, Anderson, is the elder law attorney and chief writer of this legislation. Since Casey Kasem passed, Kerri has worked diligently on legislation throughout the United States that would protect loved ones from elder abuse like what her father experienced. And with that, I will have Robert talking to you about Senate Bill 713, and Kerri will talk to you about her experience with her father. And once again, I want to thank you for taking this up today, Senate Bill 713, for testimony today, and I will have Kerri lead off and talk to us about the experience that she had with her father.
Hello, good afternoon, committee members and Senator Jones. I am so honored to be here in front of you. You can make a huge difference in so many people's lives. My father, when he got sick enough, was taken from us by his wife. She actually said, "You're not going to see your father anymore." Those were her words after months of trying to get in to see my dad. My father and I, my brother, my sister, my dad's brother who is here today, my aunt, all my family members, my dad's friends and coworkers could not see him. He was completely isolated and blocked. He had Parkinson's and Lewy body dementia, and when he got sick enough, his wife blocked him from all his friends, family members, any communication at all to the outside world. I called the police, and they could not help us because he was in a residential home and his wife didn't want us in there. I called Adult Protective Services, and they could do nothing as well. So I went to court, and I thought, well, I'm just going to tell the judge. We see my dad every week. I talk to him every day on the phone. We can't get a hold of him. We just want to see him. I soon realized that in this country, as soon as you turn 18 years old, you have absolutely no rights to visitation to your parents, especially when they're ailing and they cannot speak for themselves or they have very limited mobility. My fight cost me and my family a lot of time, a lot of money, and those are things that people don't have. We had a famous last name. People knew my dad, and we had the money to fight as much as we possibly could in court. My fight cost $350,000. Most people don't have enough money for a retainer to a lawyer, much less fight a power of attorney or guardianship. So the bill that you have in front of you is common sense. It just allows a judge to rule on visitation. It's that simple. This is a human right. My father's human rights were violated. My extremely close family was torn apart. My father told the judge, "I want to see my kids." My father told the judge, "I want my kids to take care of me." But that was not possible because there was no law in place for the judge to rule on visitation. She said, "Casey Kasem wants to see his kids. Now go out in the hallway and figure it out." We didn't see him, until I won that fight 4 months later, when I could prove elder abuse. I won guardianship over my father. Most people don't. There are people in the audience here that can't see their family members, haven't seen them for a year, 2 years, 3 years, because there's an uncooperative caretaker. We need a bill in place to stop this elder abuse. It starts with isolation, because once you isolate, you can over-medicate, you can steal the estate, and then you cremate. I've been doing this 4.5 years. That is the pattern that we have seen. We have never asked for money, not one time. We just asked for visitation. That is all. And that's all we ask you to do. It's a common sense law. Thank you so much.
Yes, sir. I think you have my written testimony.
We do.
There, okay. I'm Robert Anderson, elder law attorney from the Upper Peninsula, and I'm here today to speak on behalf of Senate Bill 713, who I helped to draft with Senator Marlowe's staff. My testimony is on behalf of Kerri Kasem and the Kasem Foundation. The cause of fighting abuse and exploitation against aging, vulnerable people has been a passion of mine throughout my 35 years of practicing elder law in Michigan's Upper Peninsula and in Wisconsin, where I also am licensed. I have law degrees from both Michigan State University and Georgetown University, and I'm one of Michigan's 19 certified elder law attorneys. I was first alerted to the issue of isolation abuse when I attended the National Academy of Elder Law Attorneys Conference in Atlanta, where we heard live testimony from Mickey Rooney. And in that testimony, he described how he was isolated by his, I think, 7th wife and one of her sons, how they stole his estate. In fact, today, we have Mickey Rooney's daughter has come to visit us today. But it was when I heard Kerri Kasem speak at the 2017 Wisconsin Elder Law Conference that I really decided to take action, when she dramatically, as you heard today, learned about her father's story. I might add that at Kerri's urging, the state of Wisconsin did go forward a 1.5 years ago and institute and adopt their own family visitation law, and became the 11th state to do so, and now we have 12 states with Arkansas, and I believe there's even more states after that, I think.
9 have adopted laws that are similar.
Okay.
But they're not, we didn't go out and testify for them, but they passed them.
Great, great. Well, the national trend, senators, is announced by the ABA Commission on Aging, which is in favor of visitation legislation, as is the Uniform Law Commission. These trends and these laws support the fundamental right of a person who's aging to exercise their fundamental First Amendment right of association, which includes the right to communicate and visit with those of your choice, especially when we're dealing with family members who are close and other friends, even though frailty and mental decline may make that person defenseless and unable to speak up for their own rights. The law gives recognition of the rights of vulnerable children to visit both parents when there's a divorce. And the law recently gave long overdue recognition of the rights of young, vulnerable female gymnasts to be free from wrongful abuse by a team physician. Now, Senate Bill 713 provides practical tools to allow vulnerable aging persons to combat abusive isolating by providing a visitation remedy in the probate court. There is no doubt that isolation of vulnerable adults in Michigan is a serious problem and is a form of elder abuse. I've been seeing this for 35 years. And you know, senators, when there's the smoke of exclusion and isolation, there is often the fire of financial exploitation and physical abuse. Here's several other important reasons why Senate Bill 713 makes sense. You know, there are far too many full-blown guardianship proceedings in the probate court whose purpose is not to benefit the declining parent, but rather either to prevent certain family members from visiting with a parent or allow excluded family members to have that visitation. For example, we see in the recent case of in re guardianship of Dorothy Red, the first case that I'm aware of where these issues of isolation and family visitation came to a head. Senate Bill 713 provides a simpler petition route than just guardianship or removing the guardianship, and as a result, full-blown guardianships can be reduced. Now, a full-blown guardianship also strips away a declining person's personal freedoms and rights. So by allowing a single-issue visitation proceeding without the loss of rights, we can better preserve the aging person's independence, autonomy, and those precious freedoms. Senate Bill 713 is patterned after model legislation developed by the Kasem Foundation legal team into appropriate parts of the Estates and Protected Individuals Code, or EPIC, as we attorneys call it. Representative Lucido has offered a House bill which similarly addresses, but only the guardianship situation. You see, Senators, most of these isolation abuse situations happen outside of the guardianship, in the homes and with the powers of attorney when there is no guardianship. 713 also contains language that prevents the bad faith petitioner whose purposes in visiting a declining parent are to cause emotional harm and financial exploit the parent. Senate Bill 713 allows persons who are in control, who are in good faith, to offer the court proof of the bad faith of the petitioner for the visitation. It allows the court to limit or supervise visitation in those cases. Now, Senate Bill 713 will never receive the full support of the bar, but most attorneys and elder law attorneys will agree that abusive isolation of vulnerable adults in Michigan is a serious problem, but to get them to agree on any one specific fix in legislation will never happen. Since we sent the draft of this bill in August with Senator Marlowe's staff, we have had the issuance by the Court of Appeals of the now famous Dorothy Red case, in which visitation was the big issue. And the Court of Appeals affirmed the probate court in trying to get the whole family to be able to have the visitation. But you know, the Court of Appeals complained that Section 5310 of EPIC contains no grounds describing under what conditions a guardian should be removed. So the court invented its own criteria by holding that visitation with family members promotes a ward's social well-being, which makes complete sense. And that isolation, that person who is isolating is no longer suitable to serve as a guardian. This is why I have written additional proposed language to Section 5310, which includes the Red Court's language. I've also prepared several other proposals to improve Senate Bill 713 in response to some of the concerns by the probate judges and other members of the bar. Attached, you will see the proposed improvements that I have drafted since last August. And most importantly, I would like to draw your attention to Circuit Judge of Macomb County, Carl Marlinga, who is a circuit judge, but used to be a probate judge, and is one of the most respected members of probate judges in Michigan, in his full support for 713. Thank you.
Thank you very much for bringing this bill forward. I, too, had a situation where a lady I've known for many, many years was kidnapped by her son, taken to Vegas, over-medicated so he could steal her money and gamble it away, while her two daughters here spent their life savings to get her back. And by the time they got her back, everything was gone. So I understand completely what you're dealing with. Do we have any questions? I see none. Thank you.
Thank you.
Okay, now I have a whole stack of cards, so I'm going to ask everybody else. I need you to limit it, I'm sorry, but 2 to 3 minutes, because I want to get everybody a chance, but we have work to get done here, so I need to get through this. The first two are Mary and Mortar Kasem. Okay. I'll read the names, but I may not be able to let everybody speak. This is really getting to be a stack. Do we have Mary and Mortar Kasem? We'll get them up. Come on, up.
Thank you so much for letting us speak today and to hear our experience. In late summer of 2013, we were cut off. My husband, who is Casey's brother, were cut off from any communication with him at all. Munir tried calling, tried leaving messages, sending emails, and nothing. We got no response at all. Toward the end of 2013, we were in a position where we were begging her to let him see his brother. So a couple weeks later, it was Christmas Eve in 2013, I got an email that said she was going to allow Munir and me to visit Casey. And I responded to her and I said, when will there be a visitation limit? You know, do we have to follow any rules? And she wrote back and said, don't even worry about that. We'll handle it when you get here. We'll figure it out. So we arrived in January of 2014, and we're met at the hospital with a security guard, and we had to sign, both of us had to sign a contract that said we could visit him for 1 hour for that day. We changed because she had told us we could see him every day, and even the security guard said we could see him every day. We changed it to say daily visits. So the day right after that, we were refused visitation at all because we changed the contract. So we saw him Thursday, we did not see him Friday, and from Saturday on toward the end of the following week when we had to return home, we had to sign a contract every single day before we were allowed to visit his brother. In addition, we were given 1 hour, and that 1 hour was split between Munir and Kerri and Julie and me if I wanted to see him. Well, obviously, I'm going to step back, you know, and let them see him. So I would go in and I would say, hi, Casey, it's Mary, I love you, da-da-da-da-da. Munir is here, and he's going to come in and visit, and then I'll come in and say goodbye, which I did. The security guard took very detailed notes and reported to Jean everything that was said and done during our visit. And when she found out that I was visiting first thing and then going back to say goodbye, she changed the rules and said, once you leave the room, you can't go back. It's like there's no rhyme or reason for that. So my husband lost a ton of weight under a doctor's care, and we never got to see him again until Kerri got conservatorship, guardianship over his health care, and we arrived in Seattle at St. Anthony's Hospital. By that time, Casey was really pretty much gone, and I do believe he died a week later. So our last memories are like rubbing his feet, rubbing his hair, and at one point there was a baseball game on, and he and Munir would play baseball. They loved baseball, and when they were younger, they played a lot of it. there was a baseball game on, and Manir, I'm sorry. Manir stood behind Casey at the bed and put his head on Casey's shoulder and whispered a play-by-play of the baseball game. And that was all we had the opportunity to do. So again, I appreciate you hearing from us, and I really, really hope this bill passes in Michigan, in Louisiana, wherever. It really makes a difference. Thank you.
Thank you for making the trip.
Thank you.
I'll now invite up Kelly Rooney and Travis Campbell.
Good afternoon. Thank you so much for hearing us today. My name is Kelly Rooney, and I am the first daughter to the beloved Mickey Rooney, which you all probably know, and who was loved by the world. But to me and seven other siblings, he was our daddy. And we loved him very much, and we know he loved us. It was a slow isolation that kept us from seeing him. My sisters and I made special surprise visits, which we started and began to notice the decline of the clothes he was wearing and how he was being treated. The last time I saw him, he disclosed to us the abuse that he was entailing, and I demanded that he leave with us that day. He was very, very afraid and very vulnerable and said he didn't want it to happen that way. I have a lot of guilt because he didn't get to come with us that day. My sister and I asked him to call 911 if anybody ever heard him again. He promised that he would. He also made a pact with us that, yes, he wanted to come and live with one of his kids, and the four of us could financially take care of him. One of my stepbrothers also knew that we wanted to take care of him. I called the police twice when I couldn't get a hold of him. Special Services was called out 3 times after neighbors had heard screams and vulgarities coming from the house. My father went into conservatorship, and that entailed a completely different isolation. We were never given his phone number, his address, or anything, and we called every week talking to that conservator, begging him to let us see our dad. And he never would. He died 18 months into conservatorship. He also, before he passed, went to Capitol Hill and testified of his abuse. And I want to read to you very quickly what he said. My dad did over 300 motion pictures, but the most proudest thing he ever did was serve our country. So he was a veteran. He was in Patton's Army. He received a Bronze Star and a Purple Heart. Excuse me. This is what my dad testified on Capitol Hill. This is partly what he said. To those seniors, and especially elderly veterans like myself, I want to tell you this. You are not alone, and you have nothing to be ashamed of. If elder abuse happened to me, it can happen to anyone. I want you to know that you deserve better. My dad raised his kids to be individuals. And I became a hairdresser. I've been a hairdresser for 40 years, and I touch people and talk to people each and every day like you all do. And now together we have an opportunity to touch people and to make a difference in people's lives. I hear it from everybody that sits in my chair, somebody they know, or their family members. It is an epidemic. We're all getting old. And if any of you have children, I'm sure you don't want to be withheld from seeing your child, or your child being withheld from seeing you. It is the most heart-wrenching thing ever to go through, especially in later years, when you want to take care of them after they've taken care of you. Thank you for letting me talk today, and thanks for letting us be heard.
Thank you for making the trip. Yes, sir.
My name's Travis Campbell. I'm the eldest son of my late father, Glenn Campbell. With regards to all the stories that you hear, they're all true. I mean, isolationism, once that starts, it's just a red flag. But basically, I wanted to thank the Kasem Cares Foundation that it helped me greatly, because when I found out that he was in a home via the media, which was not a good way to find out, but if there would have been laws enacted in Tennessee at that time, it would have greatly facilitated, myself and enabling, myself and my other brothers and sisters to have greater access to my father. It got to such a point to where when my father passed away, I was actually driving down to Nashville. I live in Wichita, that's where we came from. And when he passed, my sister was not even allowed to be in the room, which is something that's, greatly disheartening. But one thing I wanted to point out is that with regard to our fathers, we have, notable fathers, but we're just here to try to help everybody. I mean, this bill, could help, a great many people, who don't have the means. And again, we ended up passing a similar law in Tennessee. But again, it would have greatly facilitated, my ability to be able to get greater access to my father if it had already been in place when he got ill. Thank you very much for allowing us to speak.
Thank you.
Senator Abate had a quick question.
Yeah, thank all of you for coming out here. I know this is a difficult subject to talk about, and what the pain that you went through with your respective families is something that no person should have to go through. And it actually probably baffles a lot of people to hear that this is actually going on. But I'm glad to be part of this bill. I'm a co-sponsor and been working on this issue because I've seen this. And you're all from big movie star families and famous people, but this happens regularly at all different levels of our society. And I have a district that has a lot of older people in it, and I had these issues come up periodically with people who've been impacted by it. And as an attorney also, and I do estate planning, these issues, when they come up, they're very, very not only emotional, but very difficult to deal with legally. So I think this legislation is a step in the right direction. I know there's some technical issues that some people like to have us take care of, and we do that. But I wanted to commend you for both your courage and for making it out here in Michigan today in a kind of a cold day, especially if you're from down south. But we really appreciate that, and I hope that you continue the fight. Thank you.
Thank you.
sirs.
Thank you.
Thank you. I have many cards from Michigan Elderly Abuse. Do we have a spokesperson for the group? Would the spokesperson for the group please come up? Ma'am, we have the votes. I don't want to delay the vote when we've got it. So I'd like to have a spokesperson for your group, if that would be okay.
I have some things that I want to also educate you on.
Yes, ma'am. Could we have somebody pick that up, please? I will let your spokesperson speak, and they'll read in all the cards, but I have the votes, and when you have the votes, you want to get it done. Okay. Okay. Go ahead. Go ahead.
Okay. My mother was a valedictorian of her high school class and president. She and our father were high school sweethearts. After high school graduation, they married. My mother worked for Chrysler, and my father fought in World War II. When my father returned, they raised 5 children. They encouraged all their children and grandchildren to acquire college degrees. They believed that God blessed us, and that in return we have the obligation to make this place a better place to live. Our father and mother were both active in their religion, and they founded 2 parishes, one in Harbor Woods and the other one in Rochester Hills. My mother volunteered for over 25 years as American Red Cross coordinator for many blood drives. She was a den mother for over 15 years for the Boy Scouts of America. Lydia took in children in her home and helped nurture and advance their young lives. She also volunteered to simulate children who came from Poland into the American school system. She took her citizenship in the United States very seriously. When serving as a juror, in the United States court system, she would go to the library, take out books, and read to help with her decision. She never discussed anything with anyone but her fellow jurors. Our parents loved the United States. They were proud that their parents made sacrifices to come to America so their children would have a better life in the United States of America. This wonderful woman was tortured. All her rights and as a human being were denied her. She was not able to enjoy the sun on her face or the cool breeze on her skin. She missed holidays, birthdays, weddings, graduations, funerals of loved ones, births and baptisms of her great-grandchildren. She was not able to bake pies or cookies or give money, a dollar bill or quarters to her grandchildren or great-grandchildren. Many relatives, nieces, nephews, aunts, friends, all wanted to see her or speak to her. They were unable to. This torture went on for 6 years, and this was the reason because Judge Justice Scott of Lapeer County and his guardians wanted to line their pocketbooks with the money she and her husband had saved together. She had fallen in her home and went to the hospital and left the hospital by ambulance to Devonshire, an adult foster care home. The locks on her home were changed. Her home was sold. The judge refused to clarify what happened to the money of the sale of her home and the items in her home. The wedding ring she wore for 69 years had been cut off her finger before she left the hospital. The judge, Justice Scott, refused to clarify as to what happened to the rings. She was declared to have Alzheimer's disease by a doctor she had never been treated by. She had never been in his office. On request of the court-appointed guardian, the doctor declared Lydia to have Alzheimer's disease. With 2 sentences, her life changed forever. She never had an attorney to represent her. Her loved ones asked for help from the chief of police of the city of Lapeer, the Michigan State Police of the Lapeer Post, the Sheriff Department of Lapeer County, the prosecutor and assistant prosecutor of Lapeer County, the social workers assigned for elderly abuse in Lapeer County, Michael Horde, supervisor of Lapeer, Sanilac, and St. Clair counties for elderly abuse, Nick Lyon, and Attorney General Bill Schuette and his office were contacted many times and were not able to help. I begged Mike Horde to get into his car to visit my mother. He refused, stating that for the same reason I cannot visit my mother, Judge Justice Scott gave him the same orders. 5 doctors strongly stated Lydia was not to go to a foster care facility, but to a medical facility. One doctor in 2015 called Justice Scott, stating that Lydia needed to go to a medical facility. The judge refused to move her. This is nothing but human trafficking, and it has to be stopped now. The World War II generation is dying off, and these judges and their cohorts are attacking now the baby boomer generation. Lydia died a horrific death on December 30th, 2017. Her sons, who are hunters, stated that they had never seen an animal die, as their mother had so much suffered. During the 6 years of her torture, her loved ones were in court 21 times. All but 2 courts were started by the judge and his appointed guardians. Not once did the judge, Justice Scott, allow a witness or allow Lydia's loved ones to speak. He would refuse any written proof of evidence. It was not admitted into the courts. In 2015, as Judge Justice Scott was leaving his bench and about to enter his chambers, I asked him, "Why are you doing this?" He turned and looked at me in the eye and stated, "She's old and she's going to die anyways." He turned and walked into his chambers. I was shocked. The effects of seniors' isolation increases their mortality. Feelings of loneliness can negative both physical and mental health. Loneliness contributes to cognitive decline and the risk of dementia, which has physical and neurological effects. Social isolation makes seniors more vulnerable to elderly abuse. The isolated adults are more likely to fall victim to abuse. It may be the result of abusers attempting to isolate the victim from other people to minimize the risk of discovery. A critical strategy of reducing elderly abuse is to speak up about the abuse, and the exploitation often goes unreported. As a prevention, maintaining connection with the seniors and loved ones help us to ensure their safety. I have witnessed the court-appointed guardians take away and not provide hearing aids to the elderly. This prevents the elderly from listening to music or participating in conversation games, watching TVs. The intense socialization and other tactics the guardians use is not to provide eyeglasses for the elderly. Socialization in citizens are linked to long-term illnesses such as chronic lung disease, arthritis, impaired mobility, and depression. It is important to provide appropriate care for our loved ones' illnesses. This can help prevent isolation for homebound seniors, such as phone calls and visits are very critical to them. Seniors have the right to go on with their care and their desire for companionship. Lonely citizens can have high blood pressure. A study has indicated that this is a direct relationship between loneliness of the older adults, the increased symbolic blood pressure. Loss of a spouse is a major risk for the loneliness, and losing a spouse in an event which comes as people enter old age has been shown to increase the senior's vulnerability to emotional and social isolation. Studies have shown that the widow is more vulnerable to become a victim of the judges and their cohorts. To all these reasons, I urge you to sign Bill 713. Our seniors need this protection now. Thank you for your time in this urgent matter.
Thank you, ma'am. Yes, ma'am.
Thank you. Good afternoon, Senators. If you've ever read the story The Giving Tree by Shel Silverstein, you know that it is a natural cycle of life for parents to give to their children as well as children helping back their parents. As long as parents are alive, they still worry and help their children. It is children's honor to bestow love back to their children who helped them in earlier years. I am a retired Detroit public school teacher with 40 years service in the classroom. I taught first graders the basic skills, including reading and math, as well as life skills, including honesty, respectfulness, and family obligations, including love and unselfish giving to protect those that we love. After my father and only sister both died of cancer, my mother resided in her condo alone in Oakland County in Bingham Farms. I started visiting her more often and noticed that my only brother, an attorney, was interfering with the visits, first by having my mother cancel lunch dates, saying she was ill, no longer attending family functions such as bridal and baby showers, and then having the police come, Franklin Police, come about every 20 minutes every time after I arrive. The police stated that my brother had court documents saying that I was not allowed on the property. I went to the courthouse and requested all documents that had been filed in my mother, my brother's, and my names. There were no such papers at Oakland County. I paid for the clerk to give me a certified letter stating that there were no such orders filed in the courts. I took that paper from the clerk's office to my mother's police department in Franklin. They made a copy of the letter for their files and told me that it would be kept with the 5 police records as a protection for me. Subsequently, when I went to my mother's, the police still came and made it very clear for me to visit. Made it very difficult. My brother's behavior toward my mother mirrored the Stockholm Syndrome, whereby a caregiver imprisons his ward and convinces her that family members do not love her and just want her money. Neither was the case. Since I was not allowed to visit my 90-year-old mother, I had to do something. I was urged to seek guardianship by family and friends. I went to guardian class at the Oakland County Courthouse. The instructor taught me how to fill out the forms and request guardianship. They also included forms on what the guardian is expected to legally do. It was later learned that the instructor was in fact a lawyer working at the abusive guardian's office and promoting that flow of traffic like a bait and switch at a used car dealership for people to go in, get their guardianship, and then switched to the court-appointed abusive guardian. Armed with the paperwork citing my brother's abuses, reasons why I should be appointed guardian, and a probate attorney, I went to court in Judge Hallmark's courtroom. After all, I'm her daughter and have her well-being at heart. According to Michigan law, MCL 700.5306, a priority list must be in place to be followed, with number 3 on the priority list as an adult child as first choice to be considered. Above number 6, the last choice, last resort, if nobody else can be found, the court was allowed to appoint a professional guardian. My rights were totally violated by Judge Hallmark. I was not even allowed to speak in her courtroom. I was given supervised visitation because of the difficulties between my brother and I, although it was my brother. He was not given supervised visitation because he is the trustee and check holder to the checks written to the guardian. And he has power of attorney over my mother's affair and writes the checks to the guardian. After the hearing, the court-appointed guardian, John Young, was laughing with my attorney. I couldn't understand why. Why didn't they come to me to ask, how is your mother doing? What's going on? John Young never spoke to me for the past year and a half. My children and I were allowed only 2 supervised visits per month. No holidays, no birthdays, no weekends were allowed. First visit, my mother was already in the hospital with urinary tract infection. How did that happen? As a woman, I know how it can happen. And I'm not going to say it here. I was not allowed to ask any questions about her condition per the case manager. Second visit, I found her face covered with bruises and lacerations. Again, I was not allowed to ask any questions per the case manager. Do not go outside, do not ask the workers. I was not allowed to find out. Third visit, I found her with swollen legs and blood all over the carpet where she sits every day. Again, I was not allowed to ask any questions how it happened. Mom ended up in the hospital with pneumonia. And the caseworker forbid us to visit her in the emergency room until my attorney finally intervened. Knowing that that might be the last time I ever see her, we were not allowed because it wasn't our, quote, visitation time of the month. The case manager from the guardian's office turned in falsified reports saying I agitated my mother and supervision must continue. The supervised visits have continued for a year and a half because of her falsified reports. The truth is, we had beautiful visits. We played Scrabble, card games, looked at old pictures of Detroit, which she recognized. We looked at family photos, sang old songs, Sentimental Journey, Glowworm that my mother loved, and at Christmas sang carols accompanied by her grandson's guitar. At the end of every visit, Mom said she wanted us to come back tomorrow. I didn't have the heart to say we couldn't and cried all the way to the car. On a recent visit, Mom said she felt like she was in prison because no one comes to see her. No one can come to see her because of the supervised visitation and court-ordered guardian. My latest court visit was last Wednesday, February 7th, 2018. Because of my whistleblowing by contacting Adult Protective Services, Attorney General's office, and went to the media for help to expose this, my mom and I and my son were punished because Judge Hallmark took away all of my supervised visitation. Now I can't see her at all because I whistleblowed. During this time, my son was so distraught during this past year and a half. He has bipolar with schizophrenia, and I warned them several times. His doctors and therapists warned the courted guardian that he cannot take these supervised visits, that he processes things in a different way. And to him, this is a complete wall built between him and his grandmother, that he tried to commit suicide. So I stand here representing him, my mother, who's still trapped in this nursing home that says she feels like she's in a prison because nobody can come and visit her. And so that's my story, and I'm sorry if I went over, but it has to be told, and it has to be told, and this has to stop. The bills have to be passed because I'm 67, I'm a baby boomer, and my time is going to be coming soon. And I don't want my children to have to go through the abuse that I see my poor mother going through and us as our family. The court-appointed guardian was a sham. It's a white-collar human trafficking, and it has to stop. It's criminal. And from what I understand, John Young has 700 wards under him. 700. How does that happen?
Ma'am, I understand your anger, and I want to assure you, wait. I want to assure you we're on your side.
Thank you.
Senator Evans has a question.
Thank you for being here. And as I listen to everyone speak at the table, I'm wondering if, you mentioned you cited the law that family has to be considered first. Have you filed a complaint with the Judicial Tenure Commission regarding the judge's ruling?
I'm going to now, and I'm getting a transcript of that because I believe she kept telling the clerk or whatever to take it off the record. And I combated by saying, put it on the record and do the right thing, because she was trying to get it off the tape or whatever.
Okay, thank you.
Thank you for listening.
Sir, you win, basically. Please.
No, thank you so much. Appreciate that.
Go ahead.
This is kind of twofold for me because I did not know that Attorney Bob Anderson was going to be here, and I'm sure that Bob Anderson didn't know I was going to be here. But my name is Gary Redd. That case that he was speaking of, Dorothy Redd, that is my mother. This is her right here. I want to begin by saying that I am the proud son of Mrs. Dorothy Redd, a 93-year-old mother, grandmother, great-grandmother, and matriarch of the Redd, Lewis, and Burke family, and a protected individual. I'd like to first just state for the record that I am so proud of my mother. She did what most people don't do, and that is she put her business and personal affairs in order. She did what society tells us all to do before we get too old to do it. That is, to make sure you have a will, make sure you have a power of attorney, make sure you have someone you trust on your bank accounts, make sure you have a life insurance policy with beneficiary, make sure you have trusted family members possibly on the deed of your property to keep it from potentially going to probate court. Make sure you have a medical advocate to make decisions for you when you are not able to make them yourselves. All of this my mother did back in 2004 and 2005, except for the quitclaim deed of which she exercised her rights to choose with the help of an attorney, Mr. Darrell Duvall Mack, back in 2011. My mother chose me, her son, to be that somebody to take care of her. I watched my mother take care of her mother over the years before she passed. Some of us get it, some of us don't. My mother always said that it was always a ram in the bush. You might have 7 sheep walking around, but there's always one in the bush that's going to do the right thing by you. She cited back then, as far as I can remember, and still to this day, that I was the most responsible son she ever had. That she loves all her sons, but that they're just not responsible. I have 4 brothers. two of my brothers, my oldest brother who's 9 years older than me and my brother who's 3 years younger than me, opposed me being the guardian and conservator of my mother. My two younger brothers agreed with it. They supported me. So many things in the Court of Appeals, and I went to the Court of Appeals after the lower court rendered their verdict. They didn't understand what was going on here. They said all my brothers, all my family. That's not true. We had certain members of my family that was doing all types of salacious, nefarious, lying, canards throughout these proceedings. Most of the time I was standing by myself because I stood in the truth. I was being 100% transparent and 100% truthful. I had an attorney with me every step of the way. My family never had an attorney. But yet still, the judge still ruled the way he did. Now, there's a hearing set in May 26, 2016, after I won the first phase of this proceedings. The judge got so mad at my family because he realized how much they lied, because they tried to get this term called undue influence. And they talk about incapacitation. Well, the judge ordered my mother to go to Beaumont Hospital for a geriatrics test. They came back with the test and said my mother was very capable of making her own decisions. But yet when I confronted the judge, I didn't really confront him, but I mentioned, I said, well, how can she be incapacitated when the hospital said she can make her own decisions? And her decision was she wanted to live with her son, Gary, because Gary has always taken care of me. He's always been there for me, and none of my other sons have done that. The judge said, well, it's just a legal term. We're just going to use incapacitation because that's the way we do it. That's not right, because everything they ruled on in that courtroom was always about my mom didn't have the right to speak. They prevented her civil rights. She testified a good dozen times in the lower court before it went to the Court of Appeals. I found out through Mr. Anderson that my case is one of the only ones that went to the Court of Appeals. Now I have that same case, the one that he spoke of, that's talking about guardianship and conservatorship. That case right now is waiting to be heard in the Supreme Court because I filed the Supreme Court papers. So I'm not sitting back just waiting and just letting these things just roll all over me because it's wrong. It's not right. And I just want to take a minute just to read just some of the things that this judge did to me and my mother. The court ordered a geriatric exam at Beaumont Hospital for my mother in 2014. Co-guardian Jennifer Kearney and myself attended the exam. When she was evaluated, she was found to be able to make her own decisions and able to choose what she wanted to do for her own well-being. My mother stated to the doctors that she wanted her son, Gary, to be her guardian and conservator. She also stated that she wanted to live with her son, Gary. When the results of the exam was presented to Judge O'Brien, he completely disregarded and ignored his findings. In fact, Judge Daniel O'Brien never mentioned the results in any of the subsequent hearings. The court literally suppressed her right to choose. The guardian ad litem, when called upon by Judge O'Brien, read his findings. He stated that Mrs. Red is well taken care of by Mr. Gary Red, that Mrs. Red is happy and content living with her son, Gary. My recommendations for this court is to grant Gary Red's petition to be Mrs. Red's guardian. Mrs. Red testified when asked by Judge O'Brien, what did you want to happen, Mrs. Red? My mother responded by saying, I want to live with my son, Gary, and not anyone else. I want my son, Gary, to be my guardian. Mrs. Red's attorney, Eric Carver, who was pro bono, stated that he talked to Mrs. Red out of the presence of her son, Gary Red, so there won't be no undue influence inferences, and she conveyed her wishes to be with her son. Mrs. Red's primary care physician, Dr. Quasi, stated in a letter to the court that Mrs. Red is doing extremely well under the care of her son, Gary. She has gained her weight back, when she lost 40 pounds while she was living in her home with 3 of my brothers, and they were not doing what they were supposed to be doing for her. She has gained all her weight back and is healthier than she has been in a long time. Judge Daniel O'Brien literally ignored all protocol of all the findings and assigned a co-guardian along with Mr. Red, myself. The co-guardian is Jennifer Kearney of Munger and Associates. The assignment of a co-guardian was totally against everyone's professional opinion and or recommendation. Judge Daniel O'Brien threatened to remove me as co-guardian when my brother Michael mentioned to him that I was evicting him from my mother's, and the other brother Sean, from the Detroit property. Judge O'Brien stated, Mr. Red, you have 5 seconds to make up your mind. Either stop the eviction or I'm moving you from co-guardian. He did not want to hear explanations as to why I was evicting my brothers. 10 months later, my brothers were behind $3,000 in utility bills. I then explained to Judge O'Brien the reason I was evicting them 10 months prior was that their refusal to pay the bills and to sign a lease agreement for transparency reasons, because they held me accountable for everything that I was doing for my mother. They wanted me to be more transparent with what I was doing for my mother than with my own well-being. Because I was being held responsible. Okay, Judge O'Brien stated, I didn't understand the situation 10 months ago. Then I stated, you never asked me why. You only threatened me and gave me 5 seconds to respond. Either stop the eviction or relinquish your co-guardianship. He then gave me permission to evict my brothers and signed an ex parte order for them to pay the $3,000 in utility bills to the companies. The utility companies, when I took it to them, they declined to honor the ex parte order. Judge O'Brien, once presented to him again, he said, well, you have to take it up in small claims court. I said, the action has adversely affected my credit rating because my name is on that deed. Judge Daniel O'Brien told my niece Katrina, my mother's granddaughter, that she had no legal standings in this court, that she was an uninterested party to the matters at hand, that she could not act as a lawyer to represent her father, Jerome, my brother, or her uncle, Michael, my brother. They need to retain a lawyer. Now, I'll listen to what you have to say, said Judge O'Brien, to a certain degree, but it would not carry any weight, very little indeed. This is a matter concerning Mrs. Red and her sons. Contrary to what Judge O'Brien said, he subsequently allowed Katrina Tao Muhammad to talk more than anybody else in the courtroom, including my own attorney who was representing me. Thomas Brennan Frazier asked for the removal of my name from my mother's life insurance policy because I used power of attorney to add my name as the beneficiary. And he cited that I may take the money and spend it on myself. Judge O'Brien never asked for verification of how my name got on my mother's life insurance policy as beneficiary. When I mentioned that, I did not take kindly to the inference that Mr. Brendan Frazier said that I was going to potentially take the money. Judge O'Brien then stated to me, that is Mrs. Red's burial money, right? So it's got to come back to the court anyway. So we're just going to take your name off of it and leave Mrs. Red's name on it. That is my order. My mother's life insurance policy was purchased 11 months before I became power of attorney. So it was impossible for me to put my name on my mother's life insurance policy. Judge O'Brien never inquired about that. I was the original and the only beneficiary on my mother's life insurance policy, and my mother chose me with explicit instructions of what she wanted me to do. Again, Judge O'Brien violated my mother's civil rights and her right to choose. Thomas Brennan Frazier said that I used my power of attorney privileges to gift myself half of my mother's home. It was found through examining the deed that I did not sign my name as power of attorney. It was signed by my mother, Mrs. Dorothy Red. Brendan Frazier then adopted the narrative, when he found that out, of undue influence and insisted that the deed be set aside in spite of my mother's testimony on a number of occasions that she put my name on that deed because everything that I did for her and her house, Judge O'Brien set aside the deed for undue influence based upon no facts. Judge O'Brien ordered me to pay half of the outstanding taxes for 2015 and 2016 when there is clearly no Michigan law that states that when a person is added to a deed, it is not their responsibility to pay the taxes or the bills. That responsibility still lies on the homeowner. Yet Judge O'Brien made me pay the taxes and the bills. Thomas Brennan Frazier and Jennifer Kearney both refused to acknowledge the bag of receipts and pictures of all the repairs I had on every hearing. They told that they're on the table to be examined if they chose to do so. Brennan Frazier quickly glanced through the picture album, then quickly put it down, never to look at or reference it again. They both acted as if the book or the receipts never existed. When it came time for Judge O'Brien to rule on the accountings, he acted as if he had no evidence to substantiate the work that was performed at the Detroit property, including a $6,000 boiler that I put into the house so I can heat the house up. They had those receipts, yet Judge O'Brien ruled not to compensate me for the $20,000 plus work that I had refurbished the house with.
Mr. Red, we're on your side. Could I ask you to wrap it up, please?
I will, thank you, Your Honor. I have one more thing that I want to read here to you. I'm sorry for being long-winded, but this is very passionate to me. My published case for the guardianship and conservatorship is pending a date in the Supreme Court as I speak. And the setting aside of the deed and the removal of my name on my mother's life insurance policy, along with the refusal to acknowledge the $20,000 plus I put into the Detroit property, is under appeal as well. In the Court of Appeals, as I speak, on February 7, 2018, the court granted permission to sell the Detroit property. I filed a motion to stay till it's reviewed in the Court of Appeals. As Dr. Martin Luther King Jr. once eloquently stated, the moral arc of the universe is long, but it bends toward justice. I pray and I hope that is so. Thank you so much for hearing me.
Thank you, sir. Did you want to come up? Go ahead, ma'am.
Hi.
Identify yourself, please, for the record. Okay. Identify yourself, please, for the record.
Thank you very much, sir. My name is Mary Angela Basso. I'm a beneficiary of the Louis G. Basso Jr. Revocable Trust. My father was a veteran, a trust estate attorney. He also wrote contracts. He lived in Oakland County since 1968. He also ran for judge. So many judges I have interviewed, and many attorneys think this won't happen to them. My father didn't think this was going to happen to him. He was an attorney. He knew how to write trusts, estates. He did his federal income taxes. He was a tax attorney and corporate attorney. Since 2014, Judge Hallmark's probate court in Oakland County has not required the trustees of my father's trust to do their duties. Judge Hallmark has not enforced the law, a court rule, or a statute. The trustees do not even feel they are compelled to follow the law. Judge Hallmark does not care whether or not Mr. Barron, a former trustee, nor Mr. Fraser, a public administrator and current trustee, is complying with the law or the trust. Mr. Barron fraudulently confiscated my inheritance with fraudulent legal documents while he was my attorney. Judge Hallmark did not force him to comply with the trust. Mr. Barron submitted accountings of the trust without receipts, without evidence, without proof for any of the numbers in the accountings. Judge Hallmark approved of fraudulent accountings of my father's trust and financial assets and property. My father left me the proceeds from the sale of the trust residence. Mr. Fraser, a public administrator, caused over $100,000 in damage to the property by not repairing the furnace and replacing the sub pump for over a year. The house is full of mold, the walls and floors are buckling, and due to no heat for 3 months, the water pipes burst, flooding the main floor and the basement. The dining room ceiling completely collapsed, missing my head. Mr. Fraser is trying to kill me with mold and insect infestation, no heat for 3 months, so I acquire respiratory diseases and pneumonia. I brought all of this evidence to the attention of Judge Linda Hallmark in Oakland County
Okay,
Court.
ma'am, we're here for elder abuse. Could you wrap this up, please?
Yes, this is elder abuse. This is how the judge is committing elder abuse against me. I am an elder. I'm 60 years old.
Ma'am, you certainly don't look it.
Thank you very much. I don't know what that means, but I work very hard at it. Judge Hallmark, with this evidence submitted in court, I asked her to remove Mr. Fraser, a public administrator who is under obligation of the Attorney General's office, and Mr. Schuette, I contacted the Attorney General's office. Bill Schuette, Mr. Moody, and Mr. Cunningham, the criminal investigator. And I documented everything Mr. Fraser has done as a public administrator. And I asked the Judge Hallmark to remove Mr. Fraser. Judge Hallmark did not monitor Mr. Fraser's neglect and destruction of my father's trusts and assets and property. His abuse is targeting me, who is 60 years old and an elder, to become sick and homeless. I'm about to become evicted. He's confiscating my home. Mr. Fraser has tried to go around the courts. He came to the West Bloomfield Police Department with none of the correct legal documents and asked the police to evict me. And the West Bloomfield Police Department refused because he did not come with a writ of eviction. My father wrote in the trust, it is totally illegal for me to be evicted. It is my home that I inherited. Mr.
Okay, ma'am.
Okay.
Please wrap it up. We're on your side. We don't have the power to do anything with that judge. We only have the power to vote on this bill.
Well, Judge Hallmark has also refused me due process. She has not allowed me to go to trial, which is my right. She has suppressed all my rights. I have no authority. I do not know where to go. I'm asking to have Judge Hallmark removed. I am also asking for a statewide county investigation of all public administrators, whether they are acting as trustees, conservators, or guardians. At some point, I will be homeless because he's just.
Okay,
So-
ma'am, I would advise you to talk to judicial tenure, to talk to the Attorney General, but
And
we're
let
here
me
to.
address that.
We're here to vote on this bill, and we don't have anything else we can do.
Okay, I am on petition 713, my point being that even if you pass it and write it and put it into legislation and make it law, Judge Linda Hallmark of Oakland County Probate Court will not follow the law. She never has for 4 years since I've been in her courtroom. I have a record, a written, documented record. I filed my claims with the Attorney General office regarding his investigation of public administrators. I filed my complaint with the Judicial Tenure Commission. I
That's the
filed
proper
my
place to go.
complaint to the Attorney Grievance Commission. I also went to the Oakland County Prosecutor's Office 3 times since 2014. They will not prosecute any elder abuse cases. Kim Worthy is the only Wayne County prosecutor, only prosecutor in Wayne County in the whole state of Michigan who will prosecute elder abuse cases.
Okay,
So
ma'am,
even if
ma'am.
you pass the 713 petition, the judges won't follow it and the prosecutors won't
Please,
prosecute.
we're with you, ma'am. We understand. And I was being truthful. You don't look 60. So please step down.
59?
No, I was going to say about 45.
Oh, 45. Okay, I got more work to do. I want shooting for 20.
I need to get 2 more people's testimony really quickly, and then we're going to take a vote on this important bill. Otherwise, we're going to go beyond our time. We won't get it out today. So let's,
Well, Senator
please,
Jones, thank you.
please make it very brief. Go ahead, ma'am.
I think most of what I want to say has been said, but I want to say a couple things that haven't been said. My mother is a single mom, and I'm her oldest child, and I've cared for her all her life. She's been my rock all my life. I've been her rock as long as I've been here. My mother's worked. She has only 1 brother and 7 sisters. Her brother's a war hero. He was in World War II. He landed in Normandy. He has so many medals and so many honorable medals that he couldn't put any more on his uniform. He has a Purple Heart. I sat with him on my mother's birthday almost 2 years ago, which is about the last time I've seen my mother. And he said, "I'm a war hero. I don't even know if I can get her out, Mimi." He said, "I think you're going to need a commando operation to get your mother out." My mother was roped into one of the most vicious, sickly, unethical, white white-collar terrorism guardianships that I've heard come out of this room today. This is a woman who was so wonderful, everybody thinks their mother's wonderful. But I can say this, love is love. I love my mother more than anyone in this world, and I even have argued about this with my husband my entire marriage. And he's often said, you love your mother more than me, and I probably do. Unfortunately, I do. My mother, though, went into a facility for a little bit of physical therapy. She worked and retired at almost 90 years old. She wasn't exercising as much. She's from a very poor family that worked for the church, worked for the Archbishop in Detroit. My grandparents were immigrants, never had money. That my mother could be roped into a guardianship and a conservatorship is definitely a sign that anyone can be roped into this nightmare. There's no trust. When it happened, I didn't even know what an estate was. That said, she went to physical therapy. She was released. She was doing great. I left for 2 weeks to go shut down my life because the insurance discharge said she shouldn't go back home alone. I was caring for her. When I went to pick her up, she had already been roped into a guardianship. The facility applied for it because they said that the insurance cut her off 10 days before I got back, and that left an unpaid bill of a few $1,000s. And because it was 10 days overdue, they went for a guardianship. I was power of attorney. They never served me. Judge Linda Hallmark. I know this is not a judicial place, but mark that name. Judge Linda Hallmark is a criminal who belongs in jail. I looked at her, I don't think I've ever been in a courtroom before. And the day she roped my mother into this, I looked at her and said, I don't know anything about what probate is. I don't know what guardianship is. I need time. I wasn't served anything. I heard about this only yesterday. I'm just coming to ask for time. And she said, that's it.
Thank you for your testimony.
Okay,
Appreciate
so I just want to say that in 17 months, she has not allowed me to see my mother.
Okay.
I
Could
promise
you wrap
this
it
is-
up in 1
I'm
minute,
telling you,
please?
this is going to be short. So here it is. My father suffered a massive stroke nearly 10 years ago that left him unable to use his right side and unable to speak and make any decisions. My father was deemed incompetent with the courts and needed a legal guardian to make only his medical decisions. His wife was given guardianship of him, but was told his daughters were to have complete access to him and his medical records. The night before his guardian took him home, she called me and she asked me if I wanted to do this the easy way or if I wanted to do it the hard way. I asked her what the hard way was. She told me that she owned my dad and she controlled him and me for the rest of her life. So after taking him home to his residence, she refused to follow the court order that his daughters were to have complete access to him and his medical conditions. His guardian then moved him to a group home where he still resides. She stopped all therapy after only 1 month of therapy, even though he was approved to get intense therapy. That was one of the first of many destructive medical decisions she made. The last time I saw my father was nearly 9 years ago when I saw him in a group home. And while looking around, I found medication all over his room and in his drawers, his floors, everywhere. My father also had a bruise on the side of his face. When we questioned the bruise to the owner, she immediately became irate and started screaming at my father. She refused him medical treatment. Immediately, I got in touch with the proper authorities about my concern. The state of Michigan went in to the home and substantiated all the claims and were fined for improper medication dispensing. Nothing was done about the bruising because the bruise had faded by the time they visited the home. After that, his guardian stopped all contact with anyone, including family, his kids, his grandkids. After several court hearings, Judge Shanna Lamborn of Ogama County Court refused to let us have contact with him. My son was able to see him about 5 years ago, which during that time, his guardian refused to even allow my son to speak to my father during the visit. At one point, she got so angry with my son, she grabbed my dad's wheelchair while he was sitting in it and shoved him into my son, screaming at him.
Thank you very much, ma'am. Can I get your name for the record? 'Cause we
Christine
didn't-
Grzymkowski.
Thank you very much. You wrapped it up very good.
Thank you.
I'll read in the cards. I have Todd Tennis from the Elder Law and Disability Rights section of the State Bar, supports the concept. I have James Ryan, the Michigan Probate and State Planning section, is opposed. Stephanie Johnson, Michigan Probate Judges Association, is opposed. I have some of the cards I'll read in here. Kathleen Wright-Braun supports. Carl Patowski supports. Jane Collins supports. Christina Bood supports. Paul Sophia supports. I'll make a motion to adopt the S1 version of Senate Bill 713. Madam Clerk, please call the roll.
Chairman Jones?
Yes.
Senator Shootmaker? Yes. Senator Rocca? Yes. Senator Emmons? Yes. Senator Bito?
Yes.
Mr. Chairman, there are 5 yeas and 0 nays. The substitute is adopted.
I'll make a motion to report the S1 version of Senate Bill 713 to the floor with recommendation the bill then pass. Madam Clerk, please call the roll.
Chairman Jones?
Yes.
Senator Shootmaker? Yes. Senator Rocca? Yes. Senator Emmons? Yes. Senator Bito?
Yes.
Mr. Chairman, there are 5 yeas and 0 nays. The bill is reported.
I'll make a motion recommending immediate effect. Without objection, immediate effect is recommended. Well done. Thank you. Okay, I must continue. Folks, do we have Representative Hornberger or staff here? Please come up. All the senators have read your bill. Please be very brief. A description?
Very brief.
You got it. You're on.
Excellent. House Bill 4500, in its essence, is very simple. It will codify the Michigan Court of Appeals decision in the People versus Ambrose. The 2016 decision clarifies that an embryo or fetus be scored as a victim when scoring offense variable 9 under the felony sentencing guidelines. Current guidelines instruct a judge to assess points if there are 2 or more victims, counting each person who was placed in danger of physical injury or loss of property, life or property, as a victim. The instructions do not define the terms victim or person. In Ambrose, the court reasoned that developments in law to criminalize acts against unborn embryos or fetuses and case law indicated that a fetus may be considered another, makes it clear that a fetus can be a victim for purposes of OV9 scoring. House Bill 4500 will not eliminate judicial discretion. All judges retain the discretion to sentence an individual consistent with his or her specific case. To clarify, Public Act 238, the Prenatal Protection Act of 1998, negates criminalizing a pregnant woman for injury or death of her own fetus by her own criminal actions. Because she is exempt from causing harm to her own unborn child, the woman will not be subjected to a pregnancy test, and neither will other victims of her crime unless they want one. So this legislation that will protect women and their unborn children, this is common sense legislation that will protect women and their children who are victims of a crime.
Thank you. Marissa Kovac, ACLU, did you want to say something?
I can keep my comments brief.
Senator Biddy, you had a question?
Yeah, no, just, well, I got the sponsor here, and I know you've had to wait a long time on this. There was the Ambrose case that you alluded to a little earlier. How does your bill go farther than Ambrose?
It just codifies the decision in Ambrose.
It's my understanding that it goes a little further than that. Or perhaps somebody, maybe the drafter can
I'm sorry,
verify that. It's my understanding that it actually goes a little further than codifying what's in Ambrose.
It codifies it into law, and then a judge still has discretion during sentencing.
Okay.
Okay. Thank you.
Marissa Kovac of the ACLU, did you want to say something? Please come forward.
Okay, in the interest of time, I have written testimony in front of you, so I'll just make a couple of main points. Our main concern is that we do believe that this bill is overly broad and could be used against pregnant women. I know Representative Hornberger cited current law that a woman couldn't be held responsible for that, but we believe that because this bill is overly broad, it doesn't specifically make that exemption, that there could be some contradictions in the law and some confusion around it. We do think that this bill goes further than codifying Ambrose. Ambrose ruled that the courts can use discretion to score a fetus or embryo as a victim. This would require that a fetus or embryo be scored as a victim for almost any crime, all crimes under OV9, which is everything except for crimes involving controlled substances. So that's a pretty wide range of crimes. That could include reckless driving. We've seen this happen in other states where laws that are meant to protect pregnant women and their future children have been used against them. In Indiana, state feticide laws have been used to criminalize women who have miscarried or tried to attempt suicide. We just don't believe that this bill is narrowly tailored enough to ensure that this isn't going to happen in Michigan. We think that current law, with the law that was passed during last session to criminalize assault of a pregnant woman, and then the Ambrose ruling, which stands strong across the state, is strong enough to protect women and their future children from crimes against them. We just don't think that the way it is written, the way that 4500 is currently drafted, that we think that it opens the door for some unintended consequences that could lead to criminalizing pregnant women that the bill, I know, is meant to protect.
Okay, thank you for your testimony. I'll now read in the cards. I have Ed Ribbett, Right to Life in support. Rebecca Master, Michigan Catholic Conference in support. Mary Pollock, American Association of Women is opposed. Amanda West, Planned Parenthood is opposed. John Shea, Criminal Defense Attorneys is opposed. I'll make a motion to report House Bill 4500 to the floor. The recommendation that the bill then pass. Madam Clerk, please call the vote.
Chairman Jones?
Yes.
Senator Shoemaker? Yes. Senator Rocca? No. Senator Emmons? Yes. Senator Bito?
No.
Mr. Chairman, there are 3 yeas and 2 nays. The bill is reported.
I'll make a motion to recommend immediate effect. Without objection, immediate effect will be recommended. We're now going to take a vote on Senate Bill 261. Senator Hertel, because of the brief time, we're going to take a vote. Senate Bill 261. I make a motion to report Senate Bill 261 to the floor with recommendation the bill then pass. Madam Clerk, please call the roll.
Chairman Jones?
Yes.
Senator Shoemaker? Yes. Senator Rocca? Yes. Senator Emmons? Yes. Senator Bito?
Yes.
Mr. Chairman, there are 5 yeas and 0 nays. The bill is reported.
I'll make a motion to report Senate Bill 262 to the floor with recommendation the bill then pass. Madam Clerk, please call the roll.
Chairman Jones?
Yes.
Senator Shoemaker? Yes. Senator Rocca? Yes. Senator Emmons? Yes. Senator Bito?
Yes.
Mr. Chairman, there are 5 yeas and 0 nays. The bill is reported.
I'll make a motion to recommend immediate effect. Without objection, immediate effect is recommended. I'll make a motion to adopt the S1 version of Senate Bill 263. Madam Clerk, please call the roll.
Chairman Jones?
Yes.
Senator Shoemaker? Yes. Senator Rocca? Yes. Senator Emmons? Yes. Senator Bito?
Yes.
Mr. Chairman, there are 5 yeas and 0 nays. The
I'll
substitute
make a
is
motion.
adopted.
Thank you. I'll make a motion to report the S1 version of Senate Bill 263 to the floor. Recommendation the bill then pass. Madam Clerk, please call the roll.
Chairman Jones?
Yes.
Senator Shoemaker? Yes. Senator Rocca? Yes. Senator Emmons? Yes. Senator Bito?
Yes.
Mr. Chairman, there are 5 yeas and 0 nays. The bill is reported.
I'll make a motion to recommend immediate effect. Without objection, immediate effect is recommended. No further business.
For 262.
Okay, I need to do, I'm sorry, 262. Senate Bill 261, I make a motion to recommend immediate effect. No objection, immediate effect is recommended. Senate Bill 262, I make a motion to recommend immediate effect. Without objection, immediate effect is recommended. Now we are adjourned.
I'm going to make a motion for blanket immediate effect.
Erica's